So why don't we go ahead and get started? I know people are still filtering in. I think it's a good time to get started. So good morning, good afternoon, everyone. My name is Catherine Amirfar. I'm the co-chair of the Public International Law Group at Debevoise. And welcome to today's webinar, Rebooting International Law for the Cyber Age. So it's very apt that today's webinar is part of Paris Arbitration Week. Since its initial start 3 years ago, Paris Arbitration Week has become a key annual event for the arbitration community, with hundreds of participants each year. And this week celebrates Paris as a key legal center. And I know I and my partners in our Paris practice, Antoine Curie, Peter Goldsmith, Ina Popova, Patrick Taylor, and Sam Rowe, are very happy to support and participate virtually in these events. I'd also like to thank our colleague in our Paris office, Romain Zamour, very much for helping with the organization of this webinar, which took a lot of work. So today we convene to discuss one of the critical issues facing the arbitral community, the impact of hostile cyber operations and hacking activities on arbitration proceedings, and what steps can and should be taken in response. So at this point in the conversation around these kinds of cyber topics, I think it's helpfully no longer a question of whether that cyber threat exists. It does. We've all witnessed some high-profile instances of arbitral proceedings being compromised in this fashion. So we're privileged to have with us today leading voices to discuss the intersection of cyber law and international arbitration and dispute resolution. So before we get started, some criminally brief introductions, but everyone has these amazing people's profiles in your materials. So starting with Gary. Gary Korn teaches at American University Washington College of Law and previously served as the staff judge advocate to U.S. Cyber Command. Luke Dembosky, I'm very lucky to call my partner at Debevoise. He co-chairs the data strategy and security practice, where he focuses, among other things, on cybersecurity incident preparation and response. Stephanie Handler is Associate General Counsel at McKinsey & Company, where she focuses on cybersecurity. And last but certainly not least, Anna Kantik is counsel at the Estonian law firm Elix Reda, and previously served as the legal advisor and head of the legal and policy team at the NATO Cooperative Cyber Defense Center of Excellence. So welcome all of you. Thank you so much for being with us here today. To our participants, welcome to you. I do want to ask you to please use the Q&A function to submit questions. We're going to try very hard to reserve time for questions from you at the end, but please use the Q&A function on the webinar and not the chat so that we can have them ready when we get there. So with no further ado, let's get started. Luke, I want to turn to you first to do a bit of table setting on this topic. What, in your view, is the nature of the cyber risk for participants in arbitration proceedings? What do we need to be aware of, and how do these threats manifest themselves?
It's a very hot topic, Catherine. There are many reasons why arbitration proceedings are targeted by hackers, and they're targeted both by criminal groups and by nation-state threat actors. And we've seen this by analogy to other types of proceedings, including court proceedings as well, and other types of bargaining situations, for example, in the merger and acquisition context. Parties to an arbitration stand a lot to lose to hackers, and so they are a prime target. Number one, for example, are simply the strategies and bargaining positions between the two parties. And so we may think of the hackers that we're facing off against only as outside parties. It's conceivable that it could be someone aligned with one of the parties to the arbitration. Certainly hope not, but that's a possibility. Even if it's not, your bargaining position and strategies may be relevant to outside parties. And so that's one consideration. The other is just the sensitive nature of other types of data at issue. For example, personal data of individuals that may be possessed or part of the documentation in connection with the proceeding. Intellectual property, including valuable trade secrets that may be the subject of the arbitration. There may be payments flowing between the parties as a result of the arbitration, or with their respective banks to be able to fund aspects of a settlement, for example. The hacking community is focused very heavily on diverting wires, usually through a phishing campaign that results in a compromise and a simple change of the destination bank account. And, a last example I'll give is just the release of embarrassing data. And that may be as part of a ransom extortion. It may simply be to undermine a competitor or just discredit another party. And so there's a lot to lose. And I guess one final point I'll make is that it's not only the parties themselves to the arbitration, it's also, for example, the law firms, the arbitration tribunal itself, the arbitral association can be on the target list. We have seen this, for example, in 2015 in connection with a dispute between the Philippines and China over maritime rights in the South China Sea, where the Permanent Court of Arbitration in The Hague suffered a hacking attack during the proceedings with the installation of malicious software, or what we call malware, to the website of the Permanent Court of Arbitration. And so those visiting the site were at risk of being infected by this malware and possibly being open to the hackers seeing data and other sensitive communications of theirs, at least knowing who was interested in the proceedings. So there's a lot to lose. It's a very high stakes issue. It involves all of the parties around the periphery of the arbitration and not just the parties themselves.
Thanks, Luke. And I'm glad you mentioned the PCA hack. I think that was one of the wake-up calls. I wouldn't call it an early wake-up call because it was relatively recent, but one of the wake-up calls to the community because it was so high profile. Stephanie, let me turn to you. So we obviously are here virtually. We're in the midst of COVID-19. And among other things, the arbitration community and frankly, the legal community, more broadly speaking, is learning to adapt in terms of going virtual, not just in hearings, but in all aspects of the dispute resolution process. What's your assessment of these circumstances here today and how that impacts the risk profile when it comes to the cyber threat?
Right. Thank you, Catherine. I think it's a great question. So as you just heard from Luke, the cyber threat to the community is not new. It is a known threat. And what we're dealing with now is how is that threat evolving and impacting as we switch to this new reality of increasingly online remote working and remote conduct of proceedings. And the COVID pandemic has brought forth this new reality for everyone. It's not just impacting the arbitration community, it's impacting the entire global community. And so we're seeing, as a result of COVID, an accelerated adoption of digital channels and tools. And we're also seeing malicious actors doubling down on exploiting these tools and enable this new normal. This transition to remote work was not an intentional proactive transition. It was a reactive response to an unpredicted disruption. And in our haste to quickly enable our teams to continue operating in the midst of a pandemic, there was a focus on getting online as quickly as possible. In some case, that focus has been less on the vulnerabilities of the tools that are critical for us to work online. And that has caused three really big categories of major vulnerabilities that I see being exposed. First, remote working has widened multiple vectors for cyber attacks. It hasn't necessarily created new vectors, but it's increased by an extraordinary degree the existing vectors. When the pandemic hit, many professionals found themselves relying on home Wi-Fi networks, which are less secure, and personal devices that may not have been properly patched or updated. Data sharing may have shifted to less secure channels in an effort to keep the lines moving and keep people working. Many individuals started using VPN software for the first time or on a more frequent basis than they previously had been. And as we all know by our use of Zoom, there's been a huge rush to adopt new video conferencing tools in which security may not have been the first priority. The first priority was getting people online and communicating and being able to enable our continued work. And so Zoom, of course, I think has received the most attention of the video conferencing tools, but many of them have come under scrutiny for security and data protection concerns that are very valid and should be reviewed. And obviously, I think as you've seen, there have been many advances in a very short period of time with these tools. And so in addition to having tools or devices that may have fallen short of the pre-pandemic standards, proper cyber hygiene has not been the top of mind priority for many people as they struggle to adapt to workarounds and enable to continue working from home settings that were much more disruptive than the office environments that we all were used to. And so that has led to kind of the second key bucket of the increase in scams, phishing scams, and social engineering scams. Those have increased exponentially. They've always been around. They've been around for years, but malicious actors are really exploiting the fact that many individuals may not be as alert to these scams, particularly as increasingly you have seen these malicious actors posing as charitable organizations or COVID resources. And the third category to highlight is websites with weak security are being exploited to deliver malware. We've had malicious actors who have been actively hiding malware inside newly created websites, such as the COVID heat maps. Once downloaded, they steal users' confidential data and launch ransomware attacks, which will lock a user system. And we've seen a tremendous surge in those in recent months. So overall, the cyber risks that we're facing are significant, and they represent a real challenge to our ability to enable arbitration proceedings and other operations to continue. Again, for the most part, the nature of these risks isn't new. Some of the highest frequency of cyber attacks are still conducted through social engineering, malware, malicious domains, and ransomware. What is new is how the malicious actors have tailored these attacks, in many cases, to incorporate these COVID-related themes to increase the chances of a successful attack. And we are seeing this play out from sophisticated criminal organizations and nation-state groups, and they present a real challenge to our operations, which I think has been highlighted through media attacks, media reporting of successful attacks, and particularly in the ransomware space and others that could impact this community. And so the approaches that are being used to mitigate these risks, in some ways, it's a continuation of what we've been doing before. But in others, we need to really tailor our cyber responses to address the unique considerations that this remote working environment has presented. So from a user perspective, mitigation can focus on really the basics: using VPN, implementing multi-factor authentication, ensuring the use of complex passwords, strengthening home networks, downloading applications and software only from trusted platforms, and ensuring latest antivirus software and patches have been installed. Cyber hygiene is another point to focus on. Being mindful of the proliferation of social engineering scams and taking that moment to pause prior to clicking on an unexpected link or attachment or text message. And of course, a third key priority for any professional organization is really ensuring that there is proper backup of documents in an independent location. We talk about, the 3-2-1 rule, where you have two backups, one backup that's in a cold storage location that cannot be accessed from those other networks. So really thinking about, in a worst case scenario, how are you going to enable a resumption of operations if your primary source of information becomes unavailable? And the next factor I'd say that companies and organizations, communities should be considering is how are they thinking about their capabilities to monitor and detect in a remote environment? Many of the organizations have focused traditionally on their corporate networks and how do you enable behavior and detection of bad behavior, potential suspicious behavior in that corporate environment. It's a very different challenge to monitor remote behavior and collaboration tools. And the last point I would say for consideration is really thinking through incident response. There is a strong likelihood of something happening, so it's just a good idea for organizations to dust off their incident response and business continuity plans and test those plans to see if there are any gaps. Most of them were not designed with our current remote working in mind, and so thinking about how a reaction and response would come to mitigate those threats if they do manifest themselves is an appropriate consideration at this point.
Thank you, Stephanie, and obviously really important tips, especially on the cyber hygiene side. I want to come back to kind of concrete responses, but before we do that, I want to pick up on something else you said, which is what we know about the identities of the perpetrators, whether they're criminal organizations or nation state groups, and obviously whether they're one or the other, the legal scheme underlying it can differ. So with that, let me turn to you, Gary, on the legal framework, again, to set the table there. So focusing for you on state responsibility, the role of state actors, what are the international rules that govern state conduct? And obviously above the use of force threshold, which can be implicated in cyber operations, and below, how would you characterize the legal landscape when it comes to cyber?
So my overall characterization would be uncertain and evolving. And for the many points that were already raised, and a great laydown of the threat environment, and Stephanie's point that there's a high likelihood that you'll have an incident, I think is true. And I wouldn't expect, unfortunately, international law, certainly the public state on state international legal structure, to provide much of a solution in the near term. Unfortunately. Now, I mean, there is general acceptance that whether it be through a cyber means or otherwise, states are prohibited from using force against each other. And that's not too controversial. And one might argue we haven't really seen any activity that you would get much consensus has crossed that threshold in terms of cyber operations. And so maybe you can argue that where the norm is more generally accepted and understood, it's had some deterrent effect. But the vast majority of activity is playing out below that threshold, and that's what we know. And I think, in the context of this discussion and arbitration, and the protection of the integrity, confidentiality, and availability of your information, it's also important to start off with an acknowledgement that from state activity, espionage is not generally considered to violate international law. States engage in espionage. And so right off the bat, international law is not going to provide a great deal of backstopping to prevent that. There's another norm that's in debate, I would say, at the moment, which has to do with what states' responsibility is for non-state or unaffiliated actors operating from their territory or using infrastructure in their territory to cause harm in other states' territory, the due diligence principle. But again, this is something that there's not a great deal of consensus on as to whether this concept, which evolved primarily in the area of environmental law, international environmental law, carries over into the cyber context. And lots of evolving questions about whether the prohibition that is generally understood in customary international law from states intervening in the internal affairs of other states, how that carries over into the cyber context, and below that threshold, whether general notions of sovereignty themselves present a bar to certain state activity in and through cyberspace. But I think we can see from the extensive amount of activity that has been happening, these regimes are not really at this point tamping down any of that activity. It's pretty constant. And then you have the other challenging question of unaffiliated or non-state actors, the sort of criminal law context, which is, other than the Budapest Convention and some cooperative measures, there's not really an international criminal law regime. It's state by state, right? It's governed by each different state and relying on what legal structures they have to deal with criminal actors as the hackers and threat actors in this space. So more work to be done, but it's still sort of, as I said, uncertain and evolving. There's a separate norms process that's developing, but even there, how you implement those norms is sort of unclear. And the last point I'll make on all this is even within this structure, we're talking primarily about state, the relations between states and whether private parties are in some ways beneficiaries of the structures that the states put into place to restrain their own activities is a whole separate question that we can explore.
Thanks, Gary. And that's a very good table setting of a complex series or environment or series of questions. Completely agree with you that these are evolving. And you yourself has been party to some of the international discussions about these international norms and how they apply in cyber, including in the context of GGE and others, to think about international rules in cyber. As you say, there's not a lot of consensus, and I agree with that characterization, about the way that state responsibility rules apply in cyberspace. But if you look at the evolution on the soft law norms, including as much as you have state participation in those discussions, what is your guess about the likelihood that in a 3 to 5 year time horizon, and that's pretty short in an international legal conversation, as you know, where do you think we're going to see some hardening of those soft law norms? Is it on the diligencing side? Where do you think there might be some content that international law gives in a concrete sense to this discussion of cyber responsibility?
I'm less optimistic about the due diligence question because it has a host of other ramifications to it. If you think through the due diligence rule, and this is something that was considered as much of a normative non-binding obligation in the GGE process as it is a debate about whether it exists as a matter of international law, it would implicate the need for each state to exercise diligence, to have greater visibility on what's happening across networks within its territory. And that itself then has implications about privacy rights and human rights. So there's countervailing issues there that make it a very difficult discussion. And it also opens up states to, accusations that they're not meeting their diligence requirements. And then other states who are harmed by these activities have a basis for self-help remedies in the form of operations and countermeasures, that they could sort of hack back as a nation. And that's, I think, difficult to advance overall. I think there's also going to be greater attention and focus, given the nature of the information environment, on questions about the intervention principle, where states are interfering in what's happening internally in other states. The challenge for, I'd say, this discussion is that is very much a conversation that focuses on the functions of a state and not necessarily on the commercial activities and private activities of the citizenry of those states or entities within those states. So I'm not sure that we'll see a great deal of action that would, in the 3 to 5 year time frame, solve the problem that we're talking about for law firms, arbitration, judicial proceedings at the moment.
Fair, definitely fair. And I think also the struggle where the non-intervention principle is such a high threshold of intervention, it almost requires a hijacking of state functions in order to be triggered, but perhaps that's not the way to think about it in cyber. But let me move on to Anakin. To you, obviously, what Gary was talking about in terms of international legal norms focus on state behavior. But of course, there is a huge component here, which is the private industry. They control a large percentage of the networks that are targeted. They're in fact implicated in cyber operations, and they're also on the defensive side in the arbitration context where they can be the victims. So with this in mind, how do you think the evolution of cyber norms impacts the legal industry in the sense of state corporation collaborations or specifically corporate conduct?
Well, As you point out in the question, first, corporations are definitely in this unfortunate receiving end of a state exercise of power through cyberspace, and I think to start even thinking about this legal remediation and this legal mm, relationship ships around this, it's essential to understand how first exactly the private sector gets affected. So they may be the direct targets, as Luke pointed out, through industrial espionage, involuntary loss of confidentiality, or direct attacks against critical infrastructure. So all those targets are clients of legal advisors. And then on the other hand, they become these means or platforms through providing services, connections, whole platforms, applications, etc. So there is, in many ways, there's every company or every corporation becomes part of this legal scheme of potentially having a claim. So the state of cooperation currently certainly differs, because we have heard of these fierce arguments between governments and private sector, for example, over the need to provide access to private sector services and products, or networks. And then on the other hand, we see instances of cooperation, such as companies taking over hosting of affected services, or providing know-how, assistance in attribution, also technical analysis. So on the one hand, I agree definitely with Gary that there is no real evolution of these government introduced cyber norms. I think there is a deliberate reluctance to invoke international law, and there even has been a suggestion from Microsoft that the industry overall, as it is suffering from this lack of government restraint, could move ahead and propose a whole new legal regime, a peacetime protective regime that would extend to companies and users against the cyber attacks and their consequences. So for the legal industry, I'd say the implications are twofold. One, it is really essential to be able to find and seek for remedies in national law. And in international issues, as Gary already alluded to, we need to look into rather curious places, such as mutual assistance treaties or specialized no harm regimes, industry-specific regulations like finance or aviation. And then on the other hand, there is a huge opportunity here I see for legal industry, because, and in particular, this investment arbitration, because cyber now is precisely an area of international relations where state interests do not necessarily align with industries, but also where private capital and operations are directly affected or indirectly affected by state actions, both host and home states. And standards of this responsible state behavior are more likely to emerge from these interest-based legal remedies than current cyber diplomacy, in my view. So the big question is, can the legal community embrace their proactive role in this? So it's not just catching up, but moving ahead, because from my own practice, I could say that it's not has been easy to convince even corporate customers of the benefits and the threats of the GDPR.
Yeah.
Yet the GDPR is a prime example of standards behavior being specified and having direct implications on both the legal industry and all the industry, and also specifying these relationships between government, user, and industry. Where do their respective liabilities and roles fall? So it was also, we discussed the cyber hygiene, and now we need to realize that cyber hygiene doesn't only represent this margin of technical awareness, but these are the features of legal liability. Increasingly, we need to establish whether not having patched the system, not having proper authentication was something that will be calculated as a discount from a premium or reduction to a ratio. So these burdens on whom exactly do we have to place them. And finally, I think the legal industry may also have rather clear and compelling answers to the questions that, as Gary pointed out, states cannot seem to be able to answer. So do cyber operations violate sovereignty? Do they violate prohibition of intervention? And I see a huge opportunity here to get some sense into this due diligence conversation.
Thank you. Let me pivot now to picking up on what you said in terms of the legal scheme, and think about some future trends and some concrete advice for our participants. Stephanie, let me start with you in this regard. So I want to take stock of the current efforts specific in the arbitration community, at least, and then we can build out. So in 2017, Debevoise issued the protocol to promote cybersecurity in international arbitration. A few months ago, or at the end of last year, a joint working group of ICA, New York City Bar, CPR issued a protocol on cybersecurity as well. What is your assessment of these efforts? How sophisticated are they? How responsive are they? How successful do you think they can be? And what more, if anything, do you think can be done going forward specific to the arbitration community?
Right, thank you. So I think as we just heard, this is a challenging legal landscape. The international legal norms are still quite unsettled. We're starting to learn more through litigation, through new laws, but effectively, there's still a lot of question about what constitutes a reasonable approach. What does that mean in terms of what an organization needs to do in addressing cybersecurity risk and how it should structure its information security program? And I think that concept of what is a reasonable approach is really the key here. We know it's impossible to be 100% secure from a cybersecurity perspective, even if unlimited resources were available. So I think the real challenge has been determining what constitutes an appropriate and prudent approach to managing the cyber threat landscape. And I think that the Debevoise protocol and the Joint Working Group protocol are really important contributions for the arbitration community for a few different reasons. First is they establish that security matters. This is something we all assume is the case as professionals who work in cybersecurity all the time. We live this, we breathe this, we see this every day, but really having accepted as a baseline that security does fit in at a very core and integral level to the arbitration community and the proceedings is an important step forward. It's laying the foundation. The second reason is that these protocols start to clarify what the risk framework is. Again, part of the challenge here is aligning on a common set of factors. The protocols do that by starting to lay out what are the factors that should be considered when organizations are determining what specific information security measures are reasonable for the circumstance, highlighting components such as what is the risk profile of the proceedings, what is the existing practice of the organizations involved, what is the resource burden, what is proportionality, efficiency, what do those categories look like? Just again, clarifying what are the factors that we're considering here. The third is outlining of the critical information security categories that you see in the Joint Working Group protocol. And again, it may seem basic to highlight that access controls, asset management, encryption, communication security, that these are some of the core categories that matter for information security. But the reality is this level of clarification is establishing and ensuring that everybody has a common foundation so that we can build our risk framework in a consistent way and think about these security elements in the same way. And the fourth aspect is really these protocols start to advance the conversation about a common lexicon. And I think, the proposal of model clauses that we see in the Joint Working Group protocol is very helpful to, again, start ensuring that we're all speaking the same language and we're all applying the same lens to the risks that are being faced by the community and how we're thinking of them, even recognizing that this is not a one-size-fits-all approach, that we have to calibrate our approach based on the unique situation of that particular proceeding. There are two areas where I think further research and thought and moving the discussion forward are appropriate. The first is the obvious one. These protocols were developed in a pre-pandemic environment when we were operating business as the old normal. Adapting these protocols and advancing the discussion to address the current cyber threat landscape, to address the current situation in which we have proceedings online being conducted through video conferencing tools that may have increased security risk, through data sharing that is happening over different channels, really thinking about what are the changes to the risk and how should the community start maturing the principles that have been laid out to address these unique considerations, I think will be very important going forward. And the other aspect that I think we should really start thinking about is, what are the norms that we want to establish for data breach disclosure? Obviously, the legal regime for a lot of different countries and states within those countries is quite clear on certain types of data breach requirements and how those need to be disclosed. And so the Debevoise protocol laid out some procedures for the disclosure of data breaches in the context of arbitral proceedings. And I think that was a really important first step, but thinking about how do we advance that and start to get to a general consensus of what are the obligations of the parties outside of the legal or regulatory requirements that may affect some of the data if it's subject to certain notifiable like GDPR or HIPAA in the United States. But how are we thinking about the responsibilities of the parties in establishing those norms? In addition, I think are some of the key areas that I would suggest in moving forward.
Thank you, Stephanie. Luke, let me turn to you about, let's do a hypothetical. Suppose there's a hacking attack in the context of arbitral proceedings and successful. How do you recommend that the stakeholders deal with the fallout? What are the pragmatic steps that need to be taken immediately, medium term, and long term?
Sure. Well, I'll start by stealing a concept from Gary's former world, being a 30-year veteran from the Army, which is something that the hacking community uses, which is preparing the battlefield. People think of hackers as simply smashing the proverbial store window and grabbing something, and there is some of that. But the more sophisticated groups, what we call the advanced persistent threat actors, they are taking time to explore the network, surveil targets. They follow activity in the news. If there's a dispute or court proceeding or arbitration, a transaction, they pay attention to that. So there's a lot of sophistication on their side, and they are effectively, even in the criminal side, organized crime, and the ones with the state apparatus behind them can do far, even far more. So a lot of it is preparing as an individual party, and that makes what you agree to in terms of the types of protocols Stephanie was discussing much more meaningful. If you've thought about how you've responded, for example, we've been doing for years simulations for our clients of these types of events, and every single time the party realizes gaps and things that they could improve on. They walk through these issues. There's obviously the notification obligations and being aware, but what resources do you have lined up to investigate? Would you need outside forensic support, for example? How would you be looking for that party in the middle of the crisis, or could you line that sort of thing up in advance? And how are the parties to the arbitration situated in that regard? I'll tell you an area that I really think people don't necessarily focus on unless they live in this world, and that's preparedness around your communications response. Boards and senior management of companies in a breach, they're not so much focused on, are we patching systems? Have we contracted with a forensic vendor? The lower level teams in the command center are dealing with that. It's, when do we come out and say something? We have incomplete information. We don't really know all that they got. We're under pressure. Clocks are ticking from a regulatory standpoint. It may already be in the media that there's been an issue, so we may be under pressure to comment. If we don't say anything, others may fill the void. and it may not be the storyline that we want. So, practicing the communication strategy and understanding where is that threshold where we think we have enough to come out and say something to convey that we're on top of it. In the context of arbitration, there's a serious consideration about speaking with one voice with the other parties to the arbitration, and perhaps even with the tribunal. And if this could be agreed in advance, or at least principles agreed in advance, that people are going to show one another any sort of public statement in advance so they're not blindsided by those. Those are the types of steps that I would recommend that parties to arbitration think about, and they're the same sorts of things that companies in general that face cyber attacks that are the best prepared companies do on a regular basis and plan and prepare for.
Thanks, Luke. Anakin, let me go to you on to pick up on that theme of the role of companies. What role do you see for companies in cyber law regimes going forward? I know you noted with interest that the Microsoft peacetime legal regime, is that a positive development? Is that a negative development? Are we looking at a nature of state corporate collaboration that goes beyond data sharing? And is that an opportunity for growth? What are the risks?
So Microsoft's approach is one approach. There are also other industry approaches that are, I would say, easier to achieve, which are just doing what you do, but doing it better. And that goes to this assuming responsibility in your own shoes, implementing better barriers, not expecting governments to put those barriers in place, but doing it in your own environment. So, and doing it also with this understanding that it's not just for your own corporation, but the bigger environment that you're part of, your customers, your cooperation partners. Then what industry can, or like corporations can also do, is offering clear contributions. And that goes back to that in majority of cases that we are aware of cyber operations, even let alone cybercrime, it is the private sector that has been instrumental in either detecting, attributing, providing instructions how to mitigate concrete technical and organizational remedies. So that is all part of our future legal standards, like current and future legal standards. I think what also is necessary is that companies better assume the role of requiring clear answers to what is expected of them, what falls upon others, and that goes back to this proactive discussions, not necessarily litigation after the fact, but really this legal certainty issues, and then. Not least, holding perpetrators accountable. So we know so many cases where cases have been never initiated or been dropped because there are faults on both sides, and companies are really careful to come public with their own flaws. And my final point, but I would say the most important point, holding governments accountable. And we all understand that corporations generally participate in this international law and norms development process through their respective governments. So that's how private sector functions. But then there is Microsoft. And we see these attempts of establishing representation in international organizations being literally in the epicenter of it. I don't know if it's a good practice, but we have to ask ourselves, our industry approach is currently more, let's say, more promising and more accountable than what our governments are settling on. And it is really the private sector that can hold the governments to their basic promises that are currently non-binding: cooperation, legal assistance. And then it's of course easier in some states, impossible in others, to establish these clear relationship, concrete relationships with governments. But I would say concreteness is what is completely missing in this conversation so far.
Understood. And we're going to open it up for questions in about 5 minutes. But before we do that, Gary, let me stay with the topic that Anakin has started us down, which is accountability and enforcement mechanisms, formal or informal. What do you think in terms of state and non-state actors holding states accountable and responsible? You touched on this before, but do you think these enforcement mechanisms are effective, or do you think we need to really go in an entirely different direction when it comes to cyber incidents?
No, I mean, I think there's a couple of themes that we've heard throughout this, and put it in sort of base terms: a rising tide lifts all boats, and trying to even states that are maneuvering their way through how much they want to be able to leverage cyber capabilities, to advance their national interests and objectives, to conduct operations. At the same time, certainly states like the United States, UK, and a host of others have also argued for elevating the overall security of the private sector to reduce the vulnerability surface overall. And so, I think looking for the mechanisms, I think, and has raised some very interesting areas where, perhaps through traditional legal mechanisms, you can, raise the costs to people operating maliciously in this space, and to start pressuring and forcing government's hands. The avenues to hold states accountable outside of states holding states accountable is more difficult. We see this right now. It's interesting. There's a number of lawsuits in the United States, for example, that have been filed against China with respect to the pandemic. And at least within the United States, there's a whole host of legal hurdles to be successful in those type of lawsuits. And then you'd have to find, at an international level, venues that you could sustain actions against sovereign states to hold them accountable. I just think it's challenging. And to go back to Luke's points, I'll invoke my military, experience. And one mantra was, you train to fight and you fight to win. And so, I think that the most immediate and effective mechanism here is not figuring this out in the midst of a breach or a problem, but having thought through this and made the resource commitments and the preparations to minimize your risk and be able to mitigate it as effectively as possible. But from a international law perspective, I think it's going to be very difficult to see where that is going to substantially reduce the malicious activity that's happening. And I do think you're going to see states being more proactive in countering. That's just part of the broader discussion about what's permissible and not permissible as a matter of international law. It's interesting we're having this discussion as part of the Paris Arbitration Forum, because less than a year ago, I think it was, at least there were reports that France conducted a pretty extensive cryptocurrency mining botnet takedown, where it took down command and control nodes and botnet nodes across a whole host of countries, in a much more proactive measure to try and counter and reduce malicious activity in the space. I think we're going to see an uptick in that, to kind of start setting some activity baselines.
Thank you. So I do want to open it up. But before I do, I want 30 seconds max on a final question, which is, what do you see, and this is entirely reductive, so forgive me, but what do you see as the single most important step legal practitioners can take to adapt to the cyber age, given all these risks that we've been discussing? Stephanie, over to you first.
I think that's a tough question in terms of one thing to do. I think because, as we described, there's not a one size fits all. There's not a silver bullet. I think the most important is being proactive and intentional, and that applying that lens to all of our interactions that are in a remote setting, I think is going to be what is going to differentiate legal practitioners who are successfully navigating these threats from those who are not.
Thank you, Luke.
I would just build on what Stephanie said, engage on these issues, embrace them. Some of us are the parents of teenagers, and if we simply let them operate and we leave the door closed, we never look into their world, we don't know what's happening, risks build up, or potential risks. So you may think it's not your space as a lawyer to dive in and roll up your sleeves, to ask what you think may be stupid questions. We've all asked those questions, and you have to engage, as Stephanie said, proactively, roll up your sleeves, get in there, and start to really take ownership of the issues.
Anakin?
Well, to not repeat, I just add another angle to it, which is, so arguably we're losing, well, some say hundreds of millions, some say like bigger numbers on yearly basis to cybercrime and this damaging or like hostile and malicious activities. I would say go after that money, meaning that money needs to be collected.
Yeah. Gary?
Yeah, I mean, I agree. It's a pretty multifaceted problem, but I would say awareness, right? We've got to raise awareness. And I think we even take this for granted among the sort of digital native or the younger generation. And I think that's not even true. They're more familiar with working with computers, et cetera. But I've even seen in the classes I teach where I bring in someone to show the hacking methodology and what can be done. And the students are flabbergasted. They're just amazed at how much vulnerability and risk there is. So I think, you've got to start with much better education. And that leads to then, convenience is not always the answer. Sometimes you've got to forego convenience to be better postured from a security perspective. And
that's certainly the hard balance to strike. Well, let me open it up. We have in the 8 minutes remaining. One question is on the risk framework and efforts in arbitration community. I think, let me take the incident response one, actually. There's one issue in arbitration proceedings is that the proceedings are confidential, and sometimes even the existence of the arbitration is confidential. How do you deal with conflicting obligations of confidentiality and disclosure? Stephanie, do you want to start us off?
Sure. I think this is a challenge. This is one of those situations where the ideal way to address this is to think about the situation beforehand. In an ideal environment, one of the discussions that should happen at the outset of the proceedings is establishing the rules of the road for the confidentiality and disclosure situation that might come from a cyber incident. Obviously, there is going to be potentially some tension when you have regulatory notification requirements. If you have information that is compromised in the context of a proceeding, but it has clear reporting requirements under HIPAA, under GDPR, under the ITAR, under whatever regulatory scheme, my legal advice would be, if you have a requirement to disclose under regulatory regimes, you need to do that. However, the confidentiality may come into play in these situations in which that there may not be a clear regulatory requirement. And so I think the way to best deal with that, and it's pushing it off a little bit, but really you want to have thought about this beforehand, and you don't want to be trying to determine how you're going to address confidentiality and disclosure as the situation is unfolding.
Absolutely. To stay with this, we have the observation from Kathleen Paisley, who was actually working on one of these working groups about the importance of data breach policies. One example she gives could be when an arbitral participant, like the arbitrator, believes they may have been breached or phished, but not whether the arbitral information has been accessed. They may determine they have no legal obligation to notify because, for example, the risk to the data subject is low. Do they have an ethical obligation to notify in the cases where they are sitting? The worry may be that if notice is given, parties will use this as an excuse to disrupt to a proceeding. So not easy. Obviously, that's a scenario that unfortunately I think happens more often than we know because these determinations are made internally. But what, if any, guidance would you give? So below the threshold of perhaps legal obligation to disclose, is there work that needs to be, or attention paid, should I say, to what are the ethical obligations in disclosing these kinds of breaches? And how should these players be making those calculations? Anakin, please.
So I think first it is really essential to understand these relationships and boxes, because nothing is totally confidential. Right? There are particular relationships that then need to be either clarified or activated. So and we see that in these confidentiality agreements, like we already mentioned that there is this obligation of disclosure. There is also this particular relationship that you can always at least inform one party, and then from there come to the discretion about next steps. But one thing here to be activated is this offer a special procedure that would then be discussed with relevant national or international authorities, whoever needs to be notified. And that would be extremely advanced, because if we get to those kinds of conversations, we are already embracing cyber as normalcy. And then finally, as to this assumption, I would say there could be a clear, bright line of that, never assuming that there is low risk when there is a sensitive process.
Thank you. All right, let me ask about, there's a question that's come in about arbitral institutions, which you can say that there's a lot of more attention, at least, paid to legal practitioners in the context of the firms, the arbitrators themselves, secretaries of tribunals. But what about the arbitral institutions in terms of both being a target and as a potential issue of liability should there be a breach incident? What guidance can you give to arbitral institutions in that respect? And Stephanie, I know this is something you've thought about. What do you think arbitral institutions sitting with this kind of risk profile should be doing?
So I think they need to be really taking this seriously and really thinking through the liability angles. You'll be familiar with the fact that the Joint Working Group protocols specifically state that the protocols and the principles that they're establishing does not create liability and should not be used to assign liability. I think that is helpful in one sense, but the reality is these organizations will likely be subject to liability if they are not following reasonable protocols. And so what reasonable means, what the security should be in place at these organizations is something that's going to be dependent on a number of factors, including the resources, the sensitivity of the matters engaged, and the overall profiles. But it is clear that liability should be top of mind in how to ensure that they are taking the steps to address the potential risk in a thoughtful and intentional manner.
Do you think we're at a stage where silence is simply no longer enough and that institutions need to actually themselves issue some kind of cyber breach protocol?
I think silence is not sufficient. We've seen this play out in the United States in the litigation system for years now, right? Silence and not addressing the threat is not going to be an excuse in a breach. And an attempt to use an ostrich approach of, well, if I don't see it, I don't know about it, it doesn't exist, that doesn't work either. And you're seeing this increasingly come to the fore with public posting of data that's been compromised, which is extremely embarrassing and raises the reputational risk and legal risk as well. And so I think when we're talking about how to address this, really creating intentional protocols is the right approach.
Okay. And then there's the one last question I think we have time for is the idea and the observation really that, why would states sign on to accepting responsibilities in the cyber realm if they're themselves involved in these practices? And is that a contributor to the fact of the point that you made, Gary, in which that there's a lot of uncertainty and lack of consensus? Because when you think about cyber operations, not just the offensive capability, but defensive capability. Do you think that that structural constraint, if you agree with it, one, is that something that you think is not going anywhere? And that's probably why we're not going to see concrete rules coming from a state process?
No, I mean, that is certainly an inhibitor, right? If you look, for example, the United States open policies on this for years have called for a free, open, and secure internet. But the United States has also acknowledged that it conducts certain cyber operations in certain contexts. So I think states are figuring out what's the right balance between being able to use this medium in a way that it protects and advances their interests, but also achieves greater security across the board, which is, I think, a recognized interest for everybody. It's hard. It's not unique necessarily, but it certainly has some unique aspects in this space. For example,
Optimistic, I think. Is that right? Is that fair? You're not optimistic in terms of getting concrete rules from a state process. Is that fair?
Not super optimistic in the short run. I think, for example, if you see all the interference issues, stuff that I've been working on lately, just using propaganda and information has never been considered really to violate international law, but we're seeing it at a scope, scale, and depth that is really, really unprecedented. And so states are going to step back and say, you know what, maybe at this point, it's better to have a rule in place, and I forego using this because on balance, it's more important to us.
And I think it's only in very recent times that I think the non-intervention principle really actually has some legs to it. It was really pretty antiquated, as you know, and only invoked extraordinarily rarely. But now we're in a completely different context, it seems.
Right.
All right. Well, thank you so much for this conversation. Very, very much enlightening and insightful. I really appreciate your time. The only downside of these, not the only, but the downside of these virtual is you can't hear the clapping. But let me assure you that there's virtual clapping across the board. Thank you very much for participating. And to everyone else, enjoy the rest of Paris Arbitration Week.